5 of the United States Constitution allows states to apply for a convention for proposing amendments. There are several organizations pushing their own Article 5 resolutions on various topics, but are all of these groups following the correct constitutional process?
I head the Article 5 Information Center in Denver. Our goal is to provide objective and accurate information to the public about the Constitution's amendment process. Back in 2011, I did some research that told me that the states cannot use state law to try to wire around the amendment process or compress or otherwise change the amendment process. The U.S. Supreme Court has been very clear on that. One of its leading cases, it says that it is not for courts or for legislatures to change the procedure that the Constitution fixes. One of the people who's now involved in the Compact for America was involved with me on that project, so he saw the cases as well. But nevertheless, he and some other folks shortly thereafter created this campaign called the Compact, which is based upon doing some things that the Supreme Court and other courts have rather clearly said that you can't do. And so at that point, practically from the beginning, I let them know that I saw some problems there. And I urged them to change their program to comply with the decided cases, but unfortunately, they haven't done that. And that can actually just lead to personal tragedy, because people can invest time and efforts and passion and money in a cause only to see it exploded when the courts strike it down.
Compact for America wants to pass a specific balanced budget amendment, and their resolution has been adopted by 4 states.
In one of the Compact for America's handouts is a statement that says our goal is to simplify the amendment process, and then we have a statement from the U.S. Supreme Court which says that you can't change the amendment process in that sort of way. The procedure is laid out in Article 5 of the United States Constitution. Any amendment, in order to become part of the United States Constitution, must be approved either by state legislatures or by state conventions in at least 3/4 of the states. That's called ratification, the final process that makes a proposal a constitutional amendment. The decision as to whether ratification is to be by state legislatures or by state conventions is made by Congress. That's the second to the last step. But before you even get to that step, it's necessary for the amendment to be proposed. In order for the amendment to be proposed, it can be passed by Congress, or it can be passed by a federal convention called a Convention for Proposing Amendments, which is basically a diplomatic gathering of representatives from the different state legislatures. If you want a convention, there's a step even before that, and that is that 2/3 of the states pass resolutions called applications instructing Congress to call the convention. So notice 2 things about this process. First, it is step by step. It's designed to be difficult, not impossible, but difficult. Application stage, proposal stage, Congress chooses whether ratification is going to be by legislatures or conventions, and then ratification stage. The other thing to note about this process is that there are a whole group of decision makers, and each decision maker is a particular assembly of individuals. So you have state legislatures making decisions, you have Congress making decisions, you have state conventions, and the federal convention, the Convention for Proposing Amendments, making decisions. These assemblies get their power from the Constitution. They don't get their power anywhere else. The Compact people essentially made 3 mistakes. The first mistake was that they tried to set up a system whereby state legislatures making applications could dictate to later assemblies operating in the process. So, for example, their legislation tries to make the Convention for Proposing Amendments just a rubber stamp. Well, the courts rather clearly say that none of these assemblies operating under Article 5 can make another assembly a rubber stamp. They've all got their own individual roles to play. The second mistake they made was assuming that this process can be controlled by state law. In fact, it can't be. The process is set up by the Constitution. The Constitution is the supreme law of the land, and state legislatures can't overrule that. And the third mistake that they made was assuming that when a state legislature operates under Article 5, it operates under what we call its reserved powers, the powers it had before the Constitution was ever written. And the courts tell us that, well, no, that's not right. They act under powers given to them by the Constitution. There are several organizations working on Article 5 campaigns. Convention of States is one of them. Organizations that are, in fact, following the law as it's laid out by the Constitution and by the courts. This is a constitutional right guaranteed us by the Constitution of the United States, much like the right to vote. But like the right to vote, you've got to do it properly. And that Article 5 is a lot like voting. I mean, it's a constitutional right that we have, and just as people should be encouraged to participate in the process by going to vote, so they also should be encouraged to participate in the process by engaging through their state legislatures in Article 5. It's a right that the founders gave to us, and it's a right we have an obligation to exercise and to pass on to our children.